does GL 26910A infringe on the Second Amendment, which reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." It sure seems like an infringement on the people's right to keep and bear arms. After all, what other right do the people possess where they have to get permission from the state to exercise it? Does requiring someone produce a license shift the burden of proof of a crime onto the defendant? Does requiring an out-of-state resident obtain a license in Massachusetts place an unconstitutional burden on their right to interstate travel? Was the court wrong in Commonwealth v. Harris? Does GL 269 Section 10A fail to protect the rights of residents from other states? These are all questions placed before the Lowell District Court. The facts leading up to the issuance of the complaint are not in dispute, and for the purposes of this motion, the court accepts them. No one disputes the facts of either of these cases. Both men lived in New Hampshire and hold valid carry licenses in that state. And both men exercised their right to bear arms when they crossed the state line into Massachusetts. There is no question that the holding of the U.S. Supreme Court in New York State Rifle and Pistol Association v. Bruin has changed the legal landscape on how the Second Amendment of the Constitution is interpreted, particularly how it affects existing firearm statutes and challenges to their constitutionality. Yes, the Supreme Court case in New York State Rifle and Pistol Association v. Bruin has changed the legal landscape, specifically that exercising the right to keep and bear arms is presumptively constitutional, and that governments must prove not only that their law follows the text of the Constitution, but the historical tradition of American law. In fact, the Supreme Judicial Court in Commonwealth v. Guardarda recognized for the first time that the Second Amendment to the United States guarantees an individual's right to possess and carry a firearm outside his home. Not until 2023, in the case of Commonwealth v. Guardarda, did the Supreme Judicial Court of Massachusetts recognize what the Second Amendment actually says. The people have a right to both keep or own and bear, meaning carry, arms. Prior to Guardarda, Massachusetts treated the possession of carrying a firearm outside of one's home as a privilege that was conferred on a person by the state. The court admits that, for years, Massachusetts treated the right to keep and bear arms as a privilege granted by the state. That Massachusetts officials and judges simply ignored the plain language of the Constitution and substituted their own. It was against the Bruin backdrop that the SJC reversed the long-standing law in Massachusetts that licensure to possess a firearm was not an essential element of the felony of unlawful possession of a firearm outside of the home. Massachusetts had previously required that holding a valid license to carry a firearm was an exception to the otherwise prohibition of carrying a firearm, and that requiring a defendant to produce a license at trial did not infringe on constitutionally protected conduct. As I've already pointed out, Massachusetts law generally prohibits the carrying of a firearm, with certain exceptions. Only after the Bruin decision did the SJC change its position, which clearly informed the judge in the Lowell District Court, John F. Coffey, in deciding these two cases. The conduct of the defendant in the instant case clearly is covered by the Second Amendment. Therefore, the burden falls on the Commonwealth to justify the law, showing that it is consistent with the country's tradition of firearm regulation. Following the advice from the Supreme Court in the Bruin decision, Judge Coffey states that carrying a firearm is clearly covered by the Second Amendment, placing the burden of proof on the Commonwealth to show that their laws are consistent with America's history when it comes to firearm regulation. As the defendant in the instant case is not a resident of Massachusetts and was in compliance with his home state's laws on the possession of a firearm, the Commonwealth needed to show some historical analog relating to disparate treatment of non-residents and must point to some historical precedent from before, during, and even after the founding that evidence a comparable tradition of regulation. The defendants in both cases were not residents of Massachusetts and were in compliance with their home state's laws. Specifically, they had valid carry licenses. But that was not good enough for Massachusetts in the past.